We got a lot of stuff we're going to look at. The first thing we're going to look at, we're going to watch a video by Judge Scalia. It's called The Role, and I want you to understand this. I'm going to preference what I'm going to say by saying this. You got to understand the principles of the principles apply on the state and federal level. We got what's called separation of powers. Okay? So Article 1 cannot exercise the same powers as Article 3. So if you got an Article 1 court, there's no way in hell it can exercise the same powers as an Article 3 court. They're two different kinds of court, and separation of powers prevents them. Now, Article 3 judges are usually in an appellate oversight of Article 1, but there's a lot of stuff that goes over in Article 1 that has no judicial oversight, like the indictment process. That's why anybody gets indicted. There's an attorney, she did a video on YouTube saying that you can indict a ham sandwich. So the first thing we're going to look at, we're going to look at the role of the Supreme Court under the Constitution. Now, we got to really watch this right here.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement along the lines that it is and properly should.
Okay, first of all, I want to give some backstory. First of all, this is a judicial committee, a judiciary committee. This means that the legislative branch of government has formed a committee, and now they're calling in the Supreme Court justices from Article 3 to have a discussion. And discussion is centered around what laws they will strike down, okay? Because Congress all the time will pass unconstitutional laws. So we're here to have a discussion on what is constitutional versus what is not constitutional. So you got Justice Breyer, Justice Scalia, you got all these guys in here before them to answer some questions. And Scalia, he is what is called an originalist. All right, so you got originalist judges, and then you got these judges that say that the Constitution is a living document, which means it changes with the time. Usually those are the liberal judges, and we got a couple of Jewish ones on the Supreme Court. And I don't think I'm wrong for calling that out, because most of the time, if you're a Democrat, you're a liberal. Liberal is just another name for communism. That's what you're not telling the American people. And I'll challenge anybody on that. Liberal is just another name for communism. It's communist. It's socialism is what it is. Socialism, just another name for that. Today, all right? So we want to make sure, I'm giving you the backstory now. So you got the senators and you got Supreme Court justices. They having a committee and to discuss. So you have Article 1 and Article 3 in the same room. And because see, what happens is when you look at United States Code annotated and United States Code, if you look in the beginning introductory of those books, you see that the Supreme Court has approved those. The reason you have procedures is because they want to make sure there are no constitutional violations. So everything in the public goes by a procedure. It's like when an officer shoots somebody down. Well, his superiors, they're going to review everything, and as long as he follows procedure, he's immune. That's what gives them their immunity. As long as they stay within the ambit of their delegated authority, they're immune from any liability. Well, they ensure they stay in the ambit of their delegated authority. Everybody in the public is given procedures. That is letting you know that you're dealing with something legislative in nature. You're not dealing with anything, Article 3 in the Constitution, because they have to have procedures in place to ensure they don't violate the Constitution. But they do it all the time. They draft laws and everything that are unconstitutional all the time, and the reason they get away with it is because we don't challenge it. So today, we're going to look at this. And Judge Scalia mysteriously ended up dead in Texas. Mysteriously ended up dead in Texas. This is one of our best Supreme Court justices we had. Let's look at it.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce.
And there it is. There it is. Okay, I want y'all, that point that senator just said, he said, since we're talking about federal legislation, we're talking about something with interstate commerce. Or in some sort of instrumentality or moving in some sort of channel of interstate commerce. That is all they have jurisdiction over. Anything commercial. I don't know why these people try to, it's so much evidence in everything that I've read to test to this. I can't believe that anyone would even have the nuts to even come up and try to say it's not true. I just don't believe. I've read indictments and everything. It's in there, interstate commerce. It's commercial in nature. This gets into the right to travel and all of that. Is it a commercial activity? So what he's about to tell him is this. He said, look, it's separation of powers. If we're dealing with something commercial, we don't even have to come and talk to you because there's something called plenary power doctrine, okay, where each of the individual branches of government, when they're exercising the powers that have been delegated to them under the Constitution, the other branches of government cannot say anything to that branch. So Article 1, Section 8, Clause 3 is the Commerce Clause. So they have been delegated that power. So now they're questioning this judge. Scalia is the one he wants to concentrate on, not Breyer. They don't like Scalia, is what I want you to peep out. They don't like Scalia. So they really hear it, but now they're respectful because this is a real fucking Supreme Court justice. I'm going to show you how they treat a judge that's not I'm going to show you how they treat an administrator that's under their authority versus a Supreme Court justice. So this is a Supreme Court justice, all right, and he's asking him a question. Okay, well, let's say it's moving in interstate commerce. Like it's a fucking trick question or something like that. Because they were saying, well, you know, bicameral passage means the House and the Senate got together and they approved it, and you have to make presentment to the president of a bill, and he signs the bill into law. That's how laws get made. Or if he vetoes the bill, he can come back and 2/3 vote, they can still make it a law. I hope everybody watched Schoolhouse Rock when they were growing up. All right? Because I learned that shit when I was like 5 or 6 years old. Okay, so If you can listen to this right here and follow along what's going on, you're gonna be all right. That's why I'm doing this, okay? So let's look at this real quick. Let's keep going.
But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the board of directors of the American Kennel Club. That passes both houses of Congress. It goes to the president. It's signed into law. And we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a sentencing commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it. I didn't think that was constitutional. So
Did you hear what he just said? That y'all do know what sentencing guidelines are. That's how everybody in federal prison gets time, okay, with sentencing guidelines. Okay, that was commission. Now, sentencing guidelines is something that is promulgated by the legislature. All right, when you go into a U.S. district court, that is an Article I court. Everything Article I starts off with U.S. citizen. Congress created that. U.S. district court, legislative court, U.S. Postal Service. All right, anything U.S. is owned by the legislature. It's legislative in nature. Congress exercises plenary power and authority over it. They just allow the Supreme Court to exercise appellate jurisdiction over their proceedings to make it look like they're doing, because they have to, because they can't violate the Constitution. Because ultimately, the protectors of the Constitution are the Article III judges. But they also took an oath to uphold it. And he's going to make that clear to him. You took an oath to uphold the Constitution as well. So right here, Scalia just put him on blast. He took this opportunity. He couldn't wait because he understand what's going on. He took this opportunity to throw right in their face, that shit y'all did was unconstitutional. Putting that on us, Article 3, to decide how many people go to prison and how much time they get, when you know these are Article I courts, that's a legislative jurisdiction, and we shouldn't have nothing to do with that. Let's get back. So right here, I want to get back on this. So Scalia just threw in his face that they forming a commission. This is a commission. They commissioned them to do this. It's called delegation of powers doctrine. This is how you can have an Article III judge sitting in an Article I court. They can delegate their powers. The legislature can delegate powers to Article II and Article III. However, they can't delegate lawmaking powers to those branches, but they do delegate powers to them to fulfill the wishes of the legislature. See, all the executive agencies are under Article II. So you see Homeland Security at what? The airport. It's called a commercial airline. That's under the authority of Congress. Y'all better wake up and start paying attention. Y'all better wake up and start paying attention. This shit is not easy. These people think you stupid. This is, once you understand what I'm talking about, it's easy to see. They not hiding anything. The problem is half of the United States of America reads on the 7th grade level. That's the issue. And the other half of y'all don't want to read. When we supposed to be exercising oversight over these people. We don't know kings in the United States of America. These people work for us. And they don't have to do that because they see these dumb motherfuckers don't know. I heard a judge say one time, it's a shame the public servants have to tell private citizens what to do. And I agree. It's a shame y'all have to go into a public venue and get a divorce and then have a public servant tell you who gonna see their child and for how long. I agree. It's a lot of immature shit people do. Yeah, see, somebody said it, same here, paid him $7,500 to take it to trial, and dude with a $3,500 retainer only to wait till the last minute to plea out to a 20-year sentence. That happens that happen to everybody. 95% of the people.
I am sure I wouldn't like your dog breeding body either. But I can't speak for the court. I don't know what the court would allow.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly.
You have to be careful because John Jay, I just read this in John Stevens' book, it's pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer.
And this is where I disagree with Justice Breyer. I read that with John Jay. Okay, that's what I was talking about when I'm going to go in and get under the analysis and interpretation of the Constitution by the Supreme Court. When I was in there studying Article 1 and Article 3 courts, what John Jay was asking them, he's like, how can a judge have two hats? Isn't that, how can I be serving under Article 1 and Article 3 at the same time? This is when that delegation of powers doctrine, this is why he's like, he's trying to cut it off. He all grinning and shit. Look at him. He grinning out, you trying to cut it off. And no. You need to go read that and study that for yourself. Because I did. And they don't like John Jay. You're going to see that. Because these were the original Supreme Court justices under Chisholm versus Georgia, which they don't teach in law school. They don't teach the court cases, one after the other. They pick and choose what cases they're going to teach these law students. But the first Supreme Court case was Chisholm versus Georgia, where the determination was made that the people are sovereign. Now, I got a guy on here, Chisholm versus Joe, Randy E. Barnett. He's an attorney. For all you attorneys out there don't like what I'm saying, I'm going to cite one of your own. He has a white paper discussing this. Matter of fact, I might do a show on that because it's real good. It's a real good white paper. We'll talk about it a little bit. But we got to get to the bottom of this. What kind of court are you going into? That is the crux of the major problem that y'all are having. Why y'all don't understand what is going on, because you don't know. You just hear the word court. And you just, I'm just going to court. I'm just going to court. You don't know what kind of court it is. Is it a basketball court? Is it a tennis court? What kind of court is it? Is it an Article 1 court or Article 3 court? Is it a legislative court? Or let's not even use Article 1 and Article 3. All right, because this guy got a phrase in that. Is it a legislative court or is it a judicial court? Because all the branches of government have their own court system. Congress has its own court. That's under Article 1, Section 8, Clause 9. And then the judiciary has a court and the military has a court. So what's never written, now the commercial courts, when we go and study the history of commercial courts, all right, that last about 4 years, they merged the commercial courts with the U.S. district courts. Go and Google commercial courts merging with U.S. district courts and read it for yourself. And watch some light bulbs start. So they merged the commercial courts with the U.S. district courts. Now, who has the authority over commerce? The legislature, Article 1, Section 8, Clause 3. So he had the authority to merge those courts. Congress. It couldn't be the judiciary because we got one Supreme Court. This is the question they don't never want to answer. This is why I come into the courtroom and I say, is this civil or criminal? It's criminal, thank you. The Constitution for the United States of America only grants this court two criminal jurisdictions. One is under the common law, which would be an Article 3 court, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction, which would be an Article 1 court. Because to be brought in an Article 1 court, you got to be under some sort of contract. Implied, it's an implied contract. George Mercier wrote a white paper, the best white paper that you can read. It's called Invisible Contracts. The man is high IQ. High IQ. It's called Invisible Contracts. That is what is connecting you. Since we've been doing this, that's what you're asking. That's why everybody says, I don't agree. That's what UCC 1-308 is about. I'm not agreeing to be in a contract that I'm not agreeing to voluntarily with full knowledge of all the material facts. You just putting me in a contract and ain't telling me everything that's involved with that contract. It's an implied contract. When I agreed to be a U.S. citizen, when I put my children in public school, when I register my car, when I use Federal Reserve notes, when I open up a bank account, when I use my social security number for anything, there's a presumption I'm a U.S. citizen. We're gonna look at that U.S. citizen too. We're gonna look at that too. Let's finish listening to them, but I want to give you some backstory on that John Jay. Okay, that's what he's talking about. The question that was posed to George Washington, okay, when they were establishing at the aborting of all of this, he was asking him, he said, hey man, how a judge gonna wear two hats? That seems unconstitutional. How they made it happen is through the delegation of powers doctrine. If you're gonna understand any of this, you gotta understand delegation of powers doctrine. Write that down. Because they don't expect y'all to know all this stuff I'm telling you. There's no way in hell any of y'all would figure out any of this. No way. No way. Ain't no way. There's no way. There's no way the average American citizen would figure out any of this. It just wouldn't happen. I can't see it. The amount of study, the amount of reading, the aptitude that is required to understand this, I don't see it.
And he was right. And he was right. And his tenure on the court proved to be short-lived in any event.
Now,
you see how that senator threw a jab at him? His tenure on the court tended to be short-lived. They don't like John Jay. You got to catch these little things. See, when you know the backstory, you can understand what's being discussed. You know, okay, this dude don't like John Jay, because they were talking about the American people are sovereigns. And they believe that the sovereignty is vested in the government. And they believe like the 9th Amendment changed the decision of Chisholm versus Georgia. No, it didn't. Not the 9th or the 11th Amendment. That's what Randy E. Barnett, that professor at Georgetown University, he wrote the white paper he was discussing, which I understood that also myself. How you going to, like they said in the case, he said, how y'all going to have sovereignty? If y'all to have sovereignty, the American people had to be sovereign. You can't get sovereignty. You have sovereignty. The sovereignty of the United States is qualified. It only within the ambit of their delegated authority, that plenary power that you exercise under territorial jurisdiction is where you exercise your sovereignty. Stop trying to make people think that you got this all-encompassing authority over everything. You don't have no authority over private property or private individuals, which is why y'all love communism, because communism is the elimination of private property. I read that out of Karl Marx, the Communist Manifesto. I believe it's on page 2 or 3. We can read that too. But they don't like John Jay. They don't like any of the original. There was only one person that dissented in that decision. Should let you know something. But Judge Iredale, he's the dissenting. He had the sole dissenting opinion in that case. But it was, that's why I don't understand. What do you mean sovereign citizen? I've never seen the word sovereign citizen in reading case law, but I see the word the American people are sovereign all over the place. So y'all done coined this phrase sovereign citizen is like really calling a person a nigger. That you can't find in no court cases. If you ask them, where did you get that word sovereign citizen? And please tell me where you derived that definition from. If you're making reference to that, because I take exception to you labeling me something that I can't find in a dictionary nowhere.
different, of course, from your leaving it to an agency to
So
fill in-
how is
to
it different then? How do those differ?
Well, because when you leave it to an agency, you are, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency because you are increasing the power of the president, your competitor, the president. You know, the separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
So the difference you would insist is based on the fact that this is an executive branch agency, which at least in theory is subject to the disposition, subject to the control, to the direction of the chief executive.
I think that's right, and I am what can I?
Judge Scalia, I'm inclined to agree with you, and I would laugh too. Of course, an executive agency is subject to the authority of the President of the United States. That's what they are. They're executive agencies. Okay? An executive agency, when you delegate authority, they can regulate activity and they can make rules for their internal operation. Okay, so a lot of you guys like to say, well, they issued an executive order, which is the most idiotic shit that I've ever. Well, they issued an executive order is for the employees of the executive branch, fool. Don't have nothing to do with you. The president is the chief of the armed forces. He gives orders. Executive order. So these rules and regulations is for their internal governance, for the things that they have the authority to regulate. Here he's talking about delegation of powers where the legislature has delegated power to an executive agency of government. He's going to get into a little bit. So he asked him, well, you know, it wasn't good because what, you know, because they're subject to the president. Like, yeah, you know, you got separation of powers. There's 7 principles of the Constitution. Separation of powers prevents them from, we put that so no one agency of government, no one branch of government will be an authority. This is why I don't understand. Everybody talk about the president. The president is just the chief of the executive branch of government. The most powerful branch of government is Congress. They're the ones y'all need to be looking at. They can declare war, do all kind of things. But something changed in 1933. Something changed when we started getting Social Security numbers and the New Deal program under Franklin Delano Roosevelt. We're going to have to get into a little discussion about that. They don't want to talk about that. They don't want to talk about that. Let's get back into this.
You're talking about the doctrine of unconstitutional delegation of legislative authority, which is a bad name for it because there is no such thing as a constitutional delegation of legislative authority. You cannot delegate legislative authority. Now, when you give rulemaking to an agency, how far can you go? Can Congress just get together and say, the president can do anything he wants and adjourn? Of course not. That has to be unconstitutional. But is it up to the courts to decide where the line is drawn between giving enough authority to the chief executive and too much authority? It is simply a non-justiciable question, and I, for one, would not let the courts apply the doctrine of unconstitutional delegation, where the delegation is to the executive.
As long as it's to the executive branch agency, then even
I wouldn't get into it. Some of my colleagues would, I suppose.
Even in the extreme situation where we passed a law saying, for example, we shall have good law. The power to make good law is hereby delegated to the Department of Good Law, which is hereby created.
I'd do that one, all right. But that's not going to happen. I'm talking about any real situation. I can't imagine my sticking my toe in that water.
Okay. And Justice Breyer, I had a question for you. I've really enjoyed reading parts of your new book, Making Our Democracy Work. It's very well written and fascinating. I think it's good reading for any law student or lawyer or American who.
Breyer come in, he started kissing his ass. Justice Breyer, I really enjoyed reading your book. Go check out Justice Breyer's nationality. Just had to throw that in there.
Wants to learn more about the system. You suggest in your book, at page 126, that there's rarely an easy answer to the question of what level of government should be primarily responsible for helping to resolve the problems that potentially call for legislation, and that the question usually turns on empirical information such that facts help determine the answers. Yeah. You go on to explain in pages 125 and 126 that very often this means that the courts ought to step aside and, if I'm understanding you correctly, have Congress more or less decide the precise contours of the boundaries of federalism. Is that, am I understanding the book correctly in that regard?
Yes, that's right. I think it's, because you go to abstract, but it's just, if you start talking abstractly, the trouble is you can characterize any individual situation usually in 15 different ways at different levels of abstraction. And depending on how you characterize it, it'll seem appropriate for a federal answer, or it'll seem appropriate for a state answer, a local answer. Is it a police department problem? You say, well, it's arresting somebody. Yeah, but you're arresting them for having guns. And, well, it's a state problem. Well, but the guns are torpedoes and they're only made internationally. And so that's so complicated and difficult that it's hard for the courts to find a general principle there. That's my point there, and that's why.
So if that's the case, and if it's also the case that under, as we read in Federalist number 45, the powers of the federal government are few and defined, whereas those of the states are numerous and indefinite, then members of Congress should read the Constitution, decide what those contours are, and restrain ourselves rather than waiting for the courts to step in and say, no, you've overstepped the bounds.
My point that I was making there is you are elected by officials in a state, and so you will make such judgments on such matters as you believe are appropriate in light of how people, partly how they feel and partly what you're trying to represent, but that it is a lot of that is your decision.
Right. Senator, of course you have to make those constitutional decisions. You take the very same oath that I take. The only reason I can look at a federal statute and say I have to disregard this because it does not comport with the Constitution, the only reason is that I've taken an oath to uphold the Constitution. You take the same oath. So, and we give deference to legislation on the assumption that the members of the Senate and of the House have tried to be faithful to their oath. And if indeed they're not even looking at or even thinking about the constitutionality of it, that presumption should not exist. So.
Are y'all starting to understand why they don't like Scalia? See how he just came in right behind Breyer and said, of course you got to follow the Constitution. I took an oath just like you took an oath.
Yes, of course you.
So in that respect and to that degree, our oath to uphold the Constitution, our commitment not to overstep the bounds of federalism, means more than simply doing that which NLRB versus Jones and Laughlin Steele or Wickard v. Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said. But we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them. Where your law does not comport with the Constitution, it seems to be a law but really isn't, and so we ignore it and apply the rest of the law, the statute notwithstanding, as one of our early cases put it. But it's really you have the first cut and the most important cut.
They had to get rid of his ass. They had to get rid of him. Like, what, nigga? And so we passing. You hear what he said? What we can get away with. They pass unconstitutional things all the time. Your Supreme Court justices are supposed to be the watchdogs of that. But the only way that they will issue a certiorari on it is you got to challenge it and bring it to their attention. But most of you don't know because you don't know what's constitutional and what's not constitutional, so they don't worry about it. He said, we just ignore the part that is unconstitutional and apply the part that is. Because they do it all the time. He said, we don't strike down your laws. We just ignore the part that's not constitutional. Well, hell, if they ignore it, how are we supposed to ever know it was unconstitutional? if you don't put it in your opinion.
Thank you. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Justice Scalia and Justice Breyer, for joining